Good morning, folks.
Good morning.
Good morning,
Morning.
Mr. Chavez.
Good morning.
Good morning.
I see Miss Jacoby. Hello, Miss Jacoby. I haven't seen you in a while.
Good to see you.
Good to see you too. Good. Okay. So let's get started. It's 9 o'clock. Mr. Moya, are we ready to get started?
Good morning, Mr. Chavez. Yes, we are recording and you are live on YouTube.
Wonderful. Okay, folks, let's get started. My name is Stephen Chavez. I'm the Land Use Hearing Officer for the City of Albuquerque. We are here today on an appeal from the ZHE. This is appeal number AC-21-12. And this is a quasi-judicial administrative hearing that we are holding via Zoom as a result of the pandemic. So we have a court reporter here. Good morning, Ms. Visaraga. She will be taking the court reporting, and a transcript will be available to anybody that wants to purchase that transcript. You can also obtain a copy of the Zoom hearing, which will be on the city's website, I believe. So, okay, let's make appearances for the record. Who is representing the appellant in this case? Mr. Comfort?
Yes, sorry, I had to get to my little audio button there. Yeah,
No worries.
thank you. I'm Frank Comfort. I represent Laurelwood. I'm the president of the Laurelwood Neighborhood Association, and also be with me is my just for clarification, Candy Patterson. She wished to speak. She's my wife, so we're going to be sharing the screen when it's her turn to speak. If that's okay.
It's okay with me. You have to call her as a witness, or I mean, if you both are making the presentation, I suppose she doesn't need to be called as a witness. I'm not going to account for time, but if you start getting duplicative, I will remind you that this is getting repetitive and we need to move on. Mr. Comfort, let me ask you a few questions, but I'd like to swear you in first before we proceed. Okay, please raise your right hand. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
Yes, I do.
Okay, so you said that you are the president of the Laurelwood Neighborhood Association?
That is correct.
Okay. By what authority do you have to represent the Neighborhood Association in this appeal? For example, did you folks hold a meeting, and did you get the authority from the rest of the board or from the members? Tell me about that.
So we held another meeting. It was on, I think it was June 12th. We had a annual meeting, and it's registered. We are registered with the ONC, and we were elected at that point in time. And I was elected president.
I understand that, and I'm not disputing that you're the president or that you are a neighborhood association under the definition of that under the ONC. My question is regarding this appeal. Because you're representing the neighborhood association, and as the president, you probably have the right to do that in this appeal, but I want to query you a little bit more on whether or not the neighborhood association held a meeting, the board of directors. Did you folks do that to give you the authority to push this appeal?
Yes, sir. We had at that meeting, we had brought this particular subject up, and consequently with other conversations with the other community members. And we all agreed.
The answer would be yes or no.
Yes, sorry.
Okay, I don't need to know the details of the okay,
right.
Thank you. And Ms. Jacoby, I will allow you cross-examination regarding Mr. Comfort's testimony regarding his authority to represent the neighborhood association. But let's move on. Ms. Jacoby, are you representing the appellant or the party opponent in this appeal?
Yes, Mr. Chavez, I represent the property owner, Unser and Ladera LLC.
Okay, and Ms. Jacoby is an attorney licensed to practice law, and so she doesn't need to be sworn in. Mr. Comfort, Ms. Jacoby, are there any preliminary matters that we need to take care of before we go into the substantive merits of this hearing?
I don't have any at this point.
Ms. Jacoby?
I don't have any either.
Okay, great. Mr. Comfort, go ahead and proceed.
Okay, I want to start off. Some of my representatives here, they'd asked me to say that it was Phyllis Bilchuk and Paul Gonzalez, John Ryback, and John Ryback, Paul Gonzalez, and Phyllis Bilchuk. They weren't able to make the meeting, but they did state that they sent letters in opposing this drive-through there on the subject matter. They wanted me to express that since they weren't able to make it, they had prior commitments. So also in reference, I wanted to start off with a reference to the 2019 meeting that apparently occurred a couple of years ago. This goes along with the, I guess, when they made that change to allow a drive-through over there. Apparently there was a meeting, information was sent out to the neighborhoods in 2019. At that time,
Mr. Comfort, let me stop you there. That's
Yeah.
not relevant for this hearing. Well, let me finish, okay?
I'm sorry.
That's not relevant for this hearing because that issue was never appealed. And so the time for appeal has gone. I'm not going to consider it in this appeal. It's not relevant for the city council to consider. What we have on the table is this appeal. And that's all I'm concerned with, okay?
Okay, yeah, fair enough. It just was it was in part of the packet that was sent. That's why I was.
I understand, and I understand there wasn't an appeal, and I don't really care why there wasn't an appeal. You may or may not have been the president, and so it's irrelevant for this hearing. You did appeal this ZHE decision, and so that's why we're here. Okay.
Yeah, fair enough. May I also share my screen? Because I just want to put up a couple of maps so that we have a reference.
You can use your time however you like.
Okay, let me see if I can do this thing here. I just got to figure out how to do this again.
Yeah,
Please
I
bear with
still
me.
haven't figured it out. Mr. Moya, it looks like you're starting. Okay, good.
Okay, so I'm just going to give a brief description of the area, because this is all part of this whole area that we're referring to. And one in question right now, this is an older map that was part of the document. In particular was here, and part of the reason for the appeal. Because our neighborhood, this is our neighborhood boundaries that come all the way over, it follows Ladera, down Unser, the I-40, and up 72nd Street. So we encompass a little bit of an area here. And on part of that, excuse me, I'm just looking at my notes here. So within this area, there's a lot of traffic, a lot of congestion in regards to this. So we have the neighborhood proper is about like 840 residents in here. There's also a, right off of Market right here is an apartment dwelling, and that's approximately 289 apartments. There's also an approval on this location here of I believe a 230 unit apartment should be coming in anytime. It was already approved. Then over on this side of the street here, which is adjacent, I believe there's about 240 apartments, dwellings over here on this side. Then I'm going to change my map here to get a little bit closer. This brings it a little bit closer to the subject area, right across the street from this area. So right here we have Walmart. Then you have all these other little strip malls here. You have the fueling station.
Mr. Comfort, let me interrupt you and ask a quick question. What page of the record is this? I know this is in the record in the first.
I'm using PR 2019-002291. It's on page 6.
Got it. Okay.
So over here, the apartments I mentioned before, which is adjacent to all this property here. So you have the fueling station here. I believe there's 8 pumps. You got AC-21-12 here at Walmart, which is directly adjacent. You have the Burger King with a drive-through. Just further south of here, you got two more drive-throughs.
Two more drive-throughs, or I thought there's a Starbucks there. Is there?
Yeah, right, Starbucks drive-through and a Taco Bell drive-through. Then the
But it's
one,
one drive-through for two uses, correct? Or am I mistaken?
that's each one has a drive-through. The Taco Bell has its own, and so does the Starbucks.
Okay, so it's two drive-throughs for two uses. I was under the impression it was one drive-through that they shared.
No,
Okay.
there's two there.
Thank you.
Then you have a little strip center here with various vendors, little restaurant, nail place, and so forth. Then you have the Burger King here. That's right adjacent to this driveway A. So this is kind of the area that we're referring to. And since this is adjacent across the street, the proposed drive-through, that's where part of the concern came in regards to the drive-through, not the restaurant itself. We don't oppose the restaurant at all, just primarily the drive-through. Excuse me. So what we have here, we have traffic issues. We have a lot of safety issues concerned, especially if you look right in here. This is a part of that driveway A, which is this location here. So all these on this side, on just the south of the proposed site, most people go through here. They'll make a left or right, but mostly they try to come out and try to go to the left here to get whichever direction they're going into. Most of the time, depending on what day it is or what time in the morning or afternoon, most people are heading south or north if it's in the afternoon, trying to get.
Let me interrupt you and direct you. And you haven't presented before in front of me, but let me tell you, I've read the entire record. I've gone through it very, very accurately. So I understand the facts of this case. The issues for this appeal essentially are that you have to show me that the ZHE erred. I mean, I'm not, this isn't your opportunity to rehash what was already done in front of the ZHE. This isn't a second hearing to overrule the ZHE, although I can do that, but I need to determine if the ZHE erred and in what way. And so it would be probably prudent of you to use your time to show me how the ZHE erred.
Okay.
I don't want to stifle your presentation but I do understand that these are the traffic issues. I actually read the TIS entirely. I read it twice because I'm not an engineer, and it takes a little extra time for me to understand some of the engineering concepts. Even though I've read literally hundreds of these, I still have a hard time. So I do understand the facts. Show me how the ZHE erred in your argument.
Well, there was no current TIS done. If you read the TIS, excuse me, you notice there's a lot of failed intersections here, especially this area here, which is in question. And it's adjacent right across the street. And there was no, at that time when the TIS was done, this the circle, at that time was the Valero. None of this was incorporated. They said it was background. Well, I don't know about being background because it directly impacts this whole area when it was developed. So once again, we're back to failed intersections with no mitigation, especially when the drive-through came in, this Burger King. So with that created here in the mornings and in the evenings at peak hours, very, very dangerous area right in here, especially right in here. Since there's no mitigation, because I also requested a TIS study be done before any development in this area. I did contact my city councilor's office. At that time,
Hold on.
Okay.
I'm not going to allow you to tell me what the city councilor's office told you, okay? Because that puts me in a position of being, an appearance of being biased. I don't want to hear that. That's not relevant. What the city council does or doesn't do during this process is irrelevant. And I'm not going to let you go down that road, okay?
Okay, because I only requested a DRB. I mean,
I don't care what you requested. Again, Mr. Comfort, I'm not trying to be rude. I'm just trying to direct you to show me the error. Now, I know that and let me help direct you a little bit. I read the TIS, and the TIS doesn't take into consideration, at least in my humble understanding of it, it doesn't take into consideration this proposal. It takes into consideration the 20 acres just south, which is the subdivision of the heritage development down there, and the 2 or 3 drive-throughs down there. But it doesn't take into consideration the site that we're talking about, that this appeal deals with. So I understand all that. Tell me how you believe the ZHE erred, okay? And tell me what you want me to do if, you know.
At the minimum, we wanted, was another study being done. We requested that from the ZHE before any development for another drive-through, that prior to any of that, that the ZHE at least try to get another traffic study done in this area because of the traffic issues and the safety issues, especially driveway A and what it causes. Because we just keep adding on, and that was the main issue here.
Okay, so you believe the ZHE erred, you believe the ZHE erred by not requiring a traffic impact study for the site. Is
Yes.
that okay?
That's correct.
Okay. Let me ask you this question. Did you submit this TIS, or did the applicant submit the TIS into the record of this?
I'm sorry, I submitted that because that's the only information I had at the time.
Got it. I understand. Okay.
There's a concern in traffic.
Go ahead. Go ahead, sir.
And that's why we're here. We're trying to at least get something going. We're very concerned in the neighborhood. I get a lot of complaints from this area. And then when another drive-through was mentioned coming in over on the proposed drive-through at that location, especially in this area, that's why we requested some form of another traffic study to be done, a current one, in regards to any drive-through, not just any proposed drive-through in that area. Because of this, there's nothing been mitigated, as you know from the TIS. That was the main issue.
Okay. Look, you may not be able to answer this question. If you can't answer it, please let me know. But I understand that the TIS that was done in 2017, obviously it was amended a couple of times, but that TIS, Terry Brown, who's testified before me many times before and over the course of many years, and I recognize him as an expert in traffic impact studies. He made recommendations, a number of recommendations for mitigation. Have any of those recommendations been actually done?
No.
These roads? Okay. So you're testifying that you know that they have not been done.
Right. The only change I think they made was this. They made a little more cutouts so more cars can stack up to try to either make a U-turn or in this case go this way. But there was a number of, and he did make a number of them. None of them obviously were for good. It's a very difficult area right in here.
Okay. Go ahead, sir. I'm sorry.
Yeah, so that's the main, I don't want to repeat myself, but that's the main concern here. It's a lot of the traffic. This is a very, very bad area. A lot of this stuff here, if it's opened up here, it's going to pull more. We get a lot of commuter that use this area here, because it's obviously, we thought it was going to be what they call a neighborhood activity center. Of course, it didn't quite turn out that way. So we added drive-ins and drive-throughs, and it's the same here across the street. So now we're having more drive-throughs. And the concern, because a lot of my people's complaint was the traffic over here, how dangerous it was. It was a safety issue to them. And the difficulty here, they're worried about more being added to this with another drive-through, especially in peak hours.
Another question for you, sir. My apologies. I will forget if I don't ask these questions as they pop up in my mind. One of the recommendations, actually, probably arguably the main recommendation from Mr. Brown in that TIS was to expand the turning from it looks like from Unser to La Ladera. He recommended that an eastbound lane be included in that turning lane. Was that done? I note that it looks like it's marked off. For example, it's just not used. There's a lane there on Unser Boulevard turning southeast to La Ladera, but it doesn't look like it's being used. Was that mitigation measure put into effect at any time?
I'm trying to picture that. I'm sorry. So I'm
Okay.
looking at the map here.
Mr. Brown's chief recommendation to me was his chief recommendation that a second eastbound right turn lane
This
be
way.
constructed.
Okay.
Correct.
Yeah. Okay. I see. That really doesn't help mitigate.
Well, no, that wasn't my question.
I'm sorry. Yes.
My
Yes.
question was,
Yes.
was it implemented?
Yes.
Okay,
Yeah, I forgot about that one, but yes.
it was. Okay, got it. Go ahead, sir. I'm sorry.
It's just like I keep indicating, this is the issue here. This doesn't really affect, we get traffic all the way backed up. It doesn't, that extra lane kind of helped, but here, right in here, you'll have traffic, have everything closed off because people are trying to head west and then south or wherever they're going. But that other lanes over here, this lane up here goes this way, and that blends into this entrance here. Now it blends in. They kind of got it marked off. It's kind of strange how they have it because you end up coming out and then going back in. So anybody coming out of this area, when they make a right out, and if it's backed up, there's going to be some issues here. You can only basically almost make a right turn, especially at those peak hours, and try to either go straight or head north if you're heading southbound.
No, I understand that the mitigation recommendations referred only to the site plan that it was speaking of, that Mr. Brown was conducting his analysis for. And it did not include, to my understanding, based on the site plan that's in the record, it did not include the site that we're dealing with today. So whether those mitigation efforts will achieve any mitigation for the drive-through questions that you have on this appeal, I could only speculate. And I'm not an expert in traffic engineering, but I would speculate that they have nothing to do with it unless it's shown, and it doesn't appear to be shown. So anyway, let's move on. Okay. Do you have anything else that you need to go over with me?
No, not at this point, because in regards to part of this, and if you have already read some of the codes the policies I stated in regards to that, I'm sure you did. It sounds like it. Those what I had in there, but like I said,
I want to remind you that this isn't a zone change, because I know that you included an argument regarding policies for zone change. This is not a zone change. Those policies are not relevant. Okay. Right.
No, I because I'm not familiar with the language, and I apologize for that. This is my first time this type of hearing at this depth, and because I'm not sure what a zone change is in reference to.
Understood.
So please forgive me in regards to that. But some of the codes that I was using in reference to this was from Mr. Strode, his developer used. Not just, and I'm sure you probably read those on my responses in regards to that. A lot of it had to do with the traffic, but at least trying to get a traffic study done prior to any issues by putting another drive-through here, and the use of this entry exit here that they're using in combination with extra space and whatever the drive-through here being directly across from a high traffic filled center cut in this area here. That was the main issue here, because what it'll occur here, because this is a very bad area at peak hours, because you got everybody going everywhere. And I just worry about what we worry about what's going to occur here with the addition of another drive-through. They try to come across or try to make a left and hang down here at those peak hours. And like I said, that was the main thing in regards to that. And that's why we requested from the ZHE, if they could actually, we would have preferred some kind of a current TIS done that addresses all this and includes what was not included originally with the Valero or the Circle K, that whole area, because everything adds up wherever it's from. That was why the request was made for this appeal.
Okay. Is there anybody else that you have to testify in this case?
Renee?
Yeah, I believe Ms. Horvath is online.
Okay. Is it Miss Birdbath, Mr. Comfort?
Horvath, Renee Horvath.
Oh, Horvath. Yeah, Renee Horvath. I'm sorry. Miss Horvath, are you here?
Yes, I am.
Good
Can you-
morning.
Good morning.
Please raise your right hand. And I'm going to swear you in. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
Yes.
Okay.
Yeah,
Proceed,
thank
Ms.
you.
Horvath.
Yes, I just want to support what Mr. Comfort, this driveway A from the is a problem because of the median cut that both the property to the north, which this appeal is about, and the shopping center to the south are going to be sharing that that driveway A. And so that map that you had on there shows that that median cut is showing that both those developments are going to be relying on that median cut for left turns in and left turns out for both those properties. And what's noticeable, what Mr. Comfort was trying to say, and what his neighborhood has been trying to say for years, is that you're putting a lot of intensive development in the shopping center to the south, and they've always had a concern about it. That's why they've been very, attended all the meetings and communicate like, hey, we're starting to get a lot of traffic issues because you're putting a lot of intensive uses with in and out that contribute to a lot of in and out traffic. These are high traffic generating uses, such as Valero was always there, the gas station. That's in and out traffic all the time. That was already busy. Then Walmart comes in, the grocery store, which the neighborhood loves because they needed one. But again, that's a lot of in and out traffic. Then they put in another gas station to the Valero. That's a lot of in and out traffic. And then they put in Starbucks and Taco Bell to the south. The neighborhoods didn't really complain about that so much because they had a little more access to Unser. But then when it came to Burger King, again, a lot of in and out traffic sharing the same driveway A out of there, and people along Ladera and coming from the Unser and Ladera intersection heading east,
May I interrupt you a second? You're kind of repeating everything that Mr. Comfort said.
okay.
Let me finish. Let me finish if I can. I understand that the traffic and the cumulative effect of the traffic from the heritage development to the south of the site that we're discussing is relevant. I have a question for you though, because you mentioned the driveway A.
Mhm.
Now, either you're confused or I'm confused, because the driveway A refers to the site plan of the subdivision of uses just south of the site that we're referring to. There's no connection with that driveway to the site plan that we're looking at for the drive-through conditional use. And so
Yes.
I don't want to get that confused. in the
No, I'm
record.
glad you brought that up because that it actually does. On the other side, their driveway lines up with driveway 8.
No, it doesn't. It doesn't. Driveway A, let me finish. Driveway A, if you look at the record, and this is the confusion I have, so I followed the trail of this. Page 54 of the record shows the market or the Heritage Marketplace site plan. Now that shows driveway A being directly on top basically in the middle of the track B that comes out of right into La Ladera. Now the driveway that you're referring to for the site that has the conditional use approval from the ZHE that you folks appealed, that is a different road. That's a different access road, and that's directly across from Marketplace. So it's not driveway A. And the reason why I bring this up is because it seems to me that the ZHE may have gotten confused with that in the testimony. I read the testimony very closely, and the driveway A does not and driveway A in the TIS does not refer to any driveway to this site. That's my understanding from reviewing this record very closely.
Yeah, because the TIS was not done for this
That's
site.
right.
And that's what Mr. Comfort is complaining about. And it needed to be done because the driveway to this property that we're talking about is directly across from driveway 8. And
No, it's not. It's not directly across from driveway. The site is directly across from driveway 8, but
I think if we
the
look at a
entry
picture,
is further east.
I think it lines up. They were relying on left-bound traffic, left turns in from the Unser
Okay.
intersection.
I don't want to debate the issue with you, but go ahead and proceed.
Yeah, I'm just saying that was a main thing, is that if the people in the Ladera Shopping Center are making their left turns out, or people with left turns in, and the people on the north side are making their left turns out and left turns in, relying on that median cut to do it, it's going to be a safety issue for traffic. And that's why they're requesting a traffic study for that, to study that. And even in the appeal that has the traffic report that Terry Brown did, he did mention that these are future concerns.
Right. He mentioned it he mentioned it in reference only to the heritage development, which did not include this site. I think it's confusing the way it was presented to the ZHE. And certainly the applicant can correct my fears of confusion. But it's my understanding, because I read that TIS very closely, and it looks like Mr. Brown was talking about mitigation measures, specifically driveway A, because of driveway A, but it had nothing to do with the driveway for this site plan. And that's my concern.
Yes.
Okay.
Because
Okay.
there is not a traffic report to show that there's going to be traffic conflicts
That's right.
with this median cut. So that's what they're asking for. And overall, they were trying to express that, hey, we're kind of doing too much high intensive in and out traffic uses. We need to balance it with uses that are less intense, because we have the most intense intersection, Unser and Ladera, where everybody congregates to get onto the I-40 freeway just south. And so it's already a busy intersection. And so, but we've complicated it with a lot of intensive high traffic generating uses, because fast foods with drive-through windows are marketable right now. But it's starting to cause problems.
Sure, okay.
And
And you're kind of repeating yourself with Mr. Comfort. I really, I'm focusing on how allegedly the ZHE may have erred.
well,
that's-
because he says, oh, okay, well, if a drive-through is permissive, or if the rules are allow it, then okay, but we're starting to see problems. So the neighborhood is communicating that we're starting to see problems with too many of these pieces, and we already have a problem. And
Got
you're
it.
just going to make it worse by doing this thing, and you didn't even do a traffic study to help demonstrate that. And how are we going to fix this problem?
Okay. Are you finished, Ms. Horvath?
And I just want to commend the neighborhood because they are really working hard to communicate these issues at these hearings
Okay.
for these approvals. So,
Okay, thank you.
yeah,
What I want to do before we go on to more testimony, I see Ms. Comfort on this Zoom call. I want to give Ms. Jacoby the opportunity to cross-examine either Mr. Comfort or you, Ms. Horvath, or both, before we get too far into this. So, Ms. Jacoby, do you have cross-examination questions for Mr. Comfort?
Thank you, Mr. Chavez. I do not. Thank you.
Okay, thank you. Do you have cross-examination questions for Ms. Horvath? Would you
No.
like?
Yeah.
Okay, okay. Thank you. Okay, so let's move on. Ms. Comfort, did you want to testify? You have to unmute. Unmute, please.
Okay.
Okay. But let me swear you in. Okay. Please raise your right hand. Do you affirm to tell the truth, the whole truth, only the truth under penalty of perjury?
Yes, I do. And
Ms. Comfort, let me stop you there. Hold on. Let me finish. Okay. Now, I'm not going to let you repeat what Mr. Comfort said or what Ms. Horvath said, because they kind of repeated. Both of them said the same thing. I mean, again, this is not a second bite at the apple. We are here only to determine if the ZHE erred, okay, and how he erred, and that's it. I've read the record, so I understand that there are traffic congestion issues, okay? Now, having admonished you with that, go ahead.
Your Honor, my name is actually Candy Patterson, not Miss Comfort.
My apologies. I saw Mr. Comfort. Okay. I'm sorry. That was a little misogynistic. I apologize.
Yes.
Can you please pronounce your last name?
Patterson, Patterson, and that is my last name.
Got it. Thank you. And again, my apologies.
Yes, sir. Yes, sir. And so what I'd like to talk about is the fact that this is a neighborhood activity center. It was designated as such back when. And what we're looking at now is intensifying the traffic in this area when you have a large community of young youth that live in and around this area that are congregated. It's the apartments where you have 795 residents living there, plus young youth or children who walk to the school, the neighborhood school, which is about 6 blocks from there to the east. It's a neighborhood school is Susie Reyes Marmon. And one of the things that I want to talk about is the developer mentioned that this is a new model, that the community, that the business is a new model. Well, during the pandemic, I believe that businesses really needed to do well. They weren't doing well because a lot of our businesses got shut down. That drive-throughs were the key thing to do to bring in, consumers. But, now we are fully open, our schools are fully open. And so I don't believe that this particular drive-through works in this area. It's very intense. You're drawing in traffic from the north and the south in the commuter traffic of Unser. And so this traffic
Ms. Patterson, Ms. Patterson, let me interrupt you. All three of you have basically ignored my requested admonitions to you. You're rehashing exactly what I asked you not to.
No, I'm going into a different.
Let me finish, please. It's important that honestly, I sympathize. I understand the traffic issues, okay? So when you just rehash them, you're not doing any services for the neighborhood association, because I need to understand how you believe the ZHE erred. And that's the issue. The testimony before the ZHE, I've already reviewed all the testimony and the arguments, and these arguments were made very clearly. And so I understand you haven't done this before, and I'm trying to be polite, but honestly, it really doesn't help just to hear this over and over and over again. Okay?
Thank you, Mr. Your Honor. This is where I was going with this. So we bring in traffic that runs to a minor arterial, which is Ladera. In order to get your coffee and burrito at the drive-through that'll be situated to the north of this, the proposed site, you have to drive in and turn and make a U-turn at Market Street to get to it. And if you can't get there because the traffic is stacked, there's too much traffic, you're going to run early in the morning, you need to get to work, so you're going to run up to Ladera and you're going to make a U-turn. The only access to this point is by a U-turn at this point in time. There's no other way to actually mitigate traffic in this area other than to make a U-turn, and that's what's going to happen here, and that's what I see. And the fact that we have students crossing the street to get to school, one accident is one too many for the children in this community. We have children who walk to school. They walk to catch the bus at the other end on Market and Hanover. And that's my greatest concern, is that if we add additional traffic through this minor arterial, it'll actually devastate our community, because one accident is one too many for our children in this community. And that's what I'm looking at. And the fact that I am a white cane user, I am blind, I walk through this neighborhood, I walk to the store, I will be unable to do this if we intensify the traffic through this area. And that's my concern. Why are we doing this? This is not a business model that fits in this area. I think it's something that may have worked along, I don't know that it would have worked at any point in time. But this is not a business model that'll work in this area, and that's my case on this. It is not a business model. It's too intense for the area and for the families, 1,600 neighbors that live in this community. It is too intense.
Okay, thank you. Ms. Jacoby, do you have any cross-examination questions for Ms. Patterson?
I do not.
Thank you so much. Okay, thank you, folks. Mr. Comfort, are there any other witnesses that you have to testify? But I won't allow any more witnesses to testify about the same thing that we've just heard, okay?
Yes, I just need, I wanted to clarify.
No. I'm asking you a question.
I'm sorry.
Do you have any more witnesses?
That's correct.
Okay, I'm sorry, I didn't hear you. Do you have any more witnesses, sir?
No, sir.
Okay, so let me tell you, you will have some time to rebut, okay? That is to clear things up. But now I'm giving an opportunity for the applicant's attorney to defend from your appeal, okay? You can ask questions, but not of her. You can ask questions of me later, and you can make an argument to rebut that argument that Ms. Jacoby is going to make now, okay? And then I will allow the planning folks to present their case if they have a case, or if my apologies, not if they have a case, but if they would like to make a presentation. And then you can cross-examine those folks, okay? If they do indeed testify. So let's proceed. Ms. Jacoby, go ahead.
Thank you, Mr. Chavez. My name is Jenica Jacoby. I work with the Rody Law Firm, and I am delighted to be here to represent the owner, Unser and Ladera. I do have with me a representative of the owner, Wes Butero, who is an engineer, and I think I will call him in a few minutes to clarify a few matters.
I was hoping you would bring an engineer on board. Thank you.
There you go. Always happy to oblige. We also have Michael Voss from Consensus Planning, who did for the owner on this project. If he has anything relevant to add. Right now, I think Wes will be the one that will sort of speak to some of the issues that were raised earlier, because I think there's maybe some confusion in the record right now that we want to make sure to clear up.
And before you present the engineer, Wes, I didn't catch his last name, but we'll get that later. Please make sure to lay a foundation for me that he's a certified engineer and he's an expert in what he does in traffic engineering, so that I don't have to do that. I appreciate it.
I will certainly do my best. Okay, so I want to start with the criteria for the to doing a conditional use. I know, Mr. Chavez, you're familiar with 6-6A3, the criteria that applies here. Really quickly, you're looking for consistency with the comp plan, complying with the IDO, including use-specific standards, not creating significant adverse impacts on neighboring properties, and not creating material adverse impacts on land from congestion traffic.
Without sufficient mitigation.
Without sufficient mitigation, exactly. Or not increasing non-residential activity too close to a residential, and not negatively impacting connectivity. And so the only issue I see it that's been raised here is that subsection D. I think you keyed in about the material adverse impacts because of traffic. That's where we're focusing today. And so the question is, did the ZHE err in considering this evidence? That I think, we've read in the record, we've heard a lot of evidence about traffic congestion around this area. It's a busy intersection. It's Unser and Ladera. That is what it is. Absolutely. I think no one's indicating this is a small intersection. No cars go through it. It's a busy intersection. Did the ZHE err, though, in approving a conditional use on this property that's at issue, the one on the north side of the street of Ladera, given the mitigation that he saw in place? And
what mitigation was in place? I didn't see any mitigation in place.
well, and that's where I'm really confused about where we are and what's going on here. And so let me, I might try sharing my screen here. Let me get the page open.
And if I can help you, here's my confusion of this. I kind of pinpointed on what confuses me about this application. I understand D is a major issue in this, so that's what we're focusing on. The TIS appeared to, I am not an expert in traffic studies. Even though I've read probably as many as you have, I still have many questions about the minutia of traffic impact studies. But it seems to me that traffic impact study only dealt with the uses that were defined or demonstrated or shown, depicted on page 54 of the record.
If I may, Mr. Chavez, I'm going to get into the traffic study more, but there's really something more critical I think we need to look at.
Sure, but let me finish my thought so that I can at least focus you and your engineer on what my concern is. And then, I mean, you can deal with your time how you want. But so my concern is that the traffic impact study that is in the record that Mr. Comfort submitted for the record only deals with the issues pertaining to that development and to the drive-throughs pertaining to that development. So there has not been, it's my understanding that there has not been any traffic impact studies or recommendations for mitigation regarding the proposed drive-through. There's nothing about that in the record. And so that's where my concern is. So my concern is, why did the ZHE and how did the ZHE determine that there are not adverse material or material adverse impacts without sufficient mitigation, when number one, I didn't see any sufficient mitigation. Number two, I didn't see any traffic analysis in the record for this conditional use. That's the conundrum I'm trying to deal with for the city council.
Thank you very much for pointing that out. And I think that the ZHE handled this very precisely. And I think maybe it's just been overlooked by the appellants and perhaps you as well. And so
it wouldn't be the first time.
I'm sharing page 8 of
okay.
Which is a copy of the ZHE decision. I think that appears several times in the record, but this is, I think, the first time. And so the ZHE put 3 conditions on its approval. And so certainly we have to comply with the use specific standards. That's number 1 here. 2, it limited only one drive-through facility on our property. We can't do multiple drive-throughs. And then 3, further conditions or for further development approvals, building permits, any further development approvals are conditioned on the applicant providing a traffic input study pursuant to the DPM, notwithstanding the thresholds and mitigations required by the DPM, which the city may use as a basis to require further mitigation of the traffic generated by the use through conditions of approval. And so the ZHE said, I'm going to approve the conditional use, but only if you go do a traffic study and deal with the city on mitigations as a result of that before you go further in the development. And by doing so, I think the ZHE fully addressed in the most professional, direct way possible what the traffic impacts would be as a result of this subject property and not other properties or other things that are going on in the neighborhood. And so my client agreed to that condition.
Well, isn't it required already? I mean, the thresholds are already met. I mean, in the pre-application conference, didn't the planners that met with the applicants, didn't they already say, you still need to do the TIS?
It is likely, Mr. Chavez, that the thresholds are met. I don't know that that determination's been made as a final.
Well, sure it has. It's in the record. I mean, it's clear that the thresholds are met. Moreover, if you look at the TIS for the impacts of the drive-throughs to the south, it's clearly those levels of service, or not levels of service, those numbers that were inputted into the analysis for a drive-through restaurant are pretty darn high. That's 1,900, roughly a little over 1,900 visits per day with a drive-through for a restaurant. Without a drive-through, it's almost half of that. So I mean, clearly the thresholds are met by this proposal, and clearly,
if there's a specific proposal with the drive-through, I agree. I don't think an exact proposal for what the uses are has been presented to make that determination with the city traffic engineer.
I see. So it may not be a restaurant. It may be something else, some other kind of drive-through.
A dry cleaner could be a drive-through. A bank can be a drive-through. There are lots of possibilities.
Okay.
For what it might be. And so as you get further in the development process, I think a final determination about that would be made. But this condition from the ZHE says, sort of regardless of what your numbers look like in that final proposal, you're going to go ahead and do a traffic study that the city can impose mitigation measures with respect to. And so that seems to be exactly what Mr. Comfort was asking for, that a traffic study be done for this property. And it's going to be done. And to the extent it indicates that mitigation is necessary, that will be done as part of the development. And so the ZHE, relying on that and placing that condition on the approval, has fully met the concerns about traffic safety with respect to our property.
I mean, I have concerns with that condition, the way it's written, but I understand the argument. Okay.
Okay. So the second point I want to make in the record at page 155 is that city traffic looked at this application and had no comments or concerns. And then,
well, wait a minute. I saw that the traffic folks didn't have any concerns. Obviously, they did have a concern, at least in the pre-application conference. They had a concern that a traffic impact study was, in your words, possibly necessary. I'm paraphrasing your words, possibly necessary based on the use because of the thresholds being met. So that's the concern. Now, with regard to the conditional use being approved as sort of a precondition of a traffic impact study, or it's a conditional traffic approval condition on a future subsequent traffic impact study. They didn't have any concerns with that, I assume. which it concerns me, and it might concern the city council. I guess my problem, and I'll be very clear, and I haven't decided one way or the other, because maybe the ZHE didn't abuse his discretion by saying, okay, do it, I'll approve it, but do a traffic impact study, and if there are mitigation measures, leave it for the DRB or for another agency to deal with. I'm guessing he has the discretion to do that. So it's really a question of, is it an abuse of discretion for him to do that rather than deny it until a traffic impact study is done? I don't know the answer to that question. I mean, I've seen it before, and I think I've dealt with the issue before. I'll have to go back and look at previous recommendations. But if you can help me with that, I mean, I need help with that question.
I appreciate that, Mr. Chavez. And I think that it is entirely appropriate for the ZHE to say, you know, the people best qualified to analyze a traffic study and determine mitigations and handle this are the city traffic engineers that do this all the time.
Sure, but having said that, that doesn't address my concern, because under subsection D for a conditional use, under that prong, you know, you have to show there are no material, you have to show there are no material adverse impacts at the time.
And that there's significant or sufficient mitigation.
Without sufficient mitigation, you still have to show that. They didn't show that. They said, we'll show it later. And so that's my concern. I mean,
I think it's pretty common in approvals to do that. I don't think that it necessarily makes sense for the ZHE to try to substitute his judgment for the city.
No, I'm not saying that
he knows that they're going to take care of it later, that he's made the requirement and that they will require mitigation. The city engineers don't look at a traffic report and go, oh, gee, I don't think you need to do anything, even though there's maybe some recommendations here or something. There's always recommendations, and there's always, you go back and forth. They actually say, I don't think that they looked hard enough at this, change this assumption. And your traffic report your analysis gets more and more toward mitigation, quite frankly, because that's what the city engineers do. That's their job. And we appreciate that they do that for traffic.
Those are recommendations, though. We're assuming there are going to be recommendations. I mean, I think we're speculating correctly. But again, that doesn't address my concern. And by the way, this debate is actually helping me understand my concern more. So my concern, as I said, is that for a conditional use, the ZHE is required to assess whether or not there are adverse impacts to the traffic system. Okay. He didn't do that. He said, I'm going to let the traffic engineers do that later. But for now, I'm going to approve the conditional use and let them assess traffic impacts later. Let them assess material impacts later. He didn't do that today, or not today, what, June, or I don't know, whenever it was, May or June. So that's my concern. And so I'm wrestling with, is that an abuse of discretion for him not to do that and say, we'll do it later, or we'll let them do it? Because I can't do it. I don't have the evidence to do it because I don't have a traffic impact analysis or study to make that call. So again, I understand there might be recommendations and those recommendations will probably be implemented at some point in time. But that's like kicking the can down the road. He's required.
I think it's simply a lack of evidences. I think it's a lack of expertise, Mr. Chavez.
Right, I see that.
Doesn't have the expertise to analyze the traffic impact study. When we reread it and we listen to the engineers, but at the end of the day, he said that the city's traffic engineer should handle that. And I think that that's absolutely a reasonable decision to do, because the city traffic engineer is capable of doing that. And that is exactly his job. Actually, I think it may be her job. And so I apologize for maybe being a little misogynistic myself.
You're being misogynistic. No, I'm not making light of that. I really feel bad about that. I don't always get embarrassed in these hearings, but I was embarrassed when Ms. Patterson let me know her name. So that was wrong. So anyway, go right ahead, Ms. Jacoby.
So now what we've got is evidence in the record about a traffic study from 2014 that was done for a property to the south. Definitely did not include our property. And we've got a traffic impact study that's going to be done in the future specific to our property and specific to the plan that's going to happen on our property. And sort of which one should the ZHE rely on to give evidence about whether there's mitigation that's going to affect a drive-through on this subject property. Frankly, the 2014 study doesn't give much evidence to what's going on our property. That's because it's not
it does give evidence to what's going on around the property directly south.
Yes, but it's not following the same traffic patterns.
No,
Frankly,
exactly.
mirrored.
Agreed.
You're not dealing with the same traffic lanes to a extent because you're coming out and turning into the right lane versus the left lane. And it really is a mirrored picture rather than something that's really direct. And the ZHE ensured that there would be a traffic study that was directly on point and looked at the uses in the property that was an issue here. And I think that he had every right and was absolutely correct to rely upon that. And so I think I would like to call Mr. Butero now.
Can you spell his last name?
Butero.
Let me swear in Mr. Butero, and then you can lay a foundation for him. Okay. Mr. Butero, are you here?
I am.
Okay. Hello. You got your right hand raised. Do you affirm
Yes,
to
sir.
tell the truth, the whole truth, and only the truth under penalty of perjury, sir?
I do.
Thank you so much. Go ahead, Ms. Jacoby.
Ms. Butero, Mr. Butero, tell me about your engineering background.
So I do need to clarify, I am not a professional traffic engineer. I am a professional engineer, professional civil engineer, but I am not a traffic engineer by background or trade. So that is not my specialty. So
How long have you been licensed?
almost 20 years.
Okay. And what has been your experience with traffic impact studies in that time?
I was a site development engineer prior to becoming on the development project manager. And so I dealt with traffic engineers on our sites, doing traffic studies, providing information to them for traffic studies, and then designing improvements associated with the recommendations for traffic studies.
And so you have dealt with the development of and the implementation of dozens, hundreds of traffic studies?
Dozens.
Excellent. You heard some testimony earlier about the traffic study that's in the record. Have you reviewed that?
I have reviewed that traffic study, yes.
And there was some testimony about mitigation efforts that were taken as a result of that as well. Did you have any corrections you'd like to make to your understanding of mitigation that's been done in the area?
I believe there were a number of mitigation items put in place at the Unser and Ladera intersection, as well as possibly at the driveways that dealt with the traffic specifically for that project. It's, again, as has been said here of late, that traffic study does not consider at all the property to the north of Ladera. So
okay. And the traffic study in the record, what assumptions does it make about the development planned for that site that's to the south?
The traffic, it made assumptions regarding the uses in that development. It was originally a traffic study. I believe there was actually a study prior to 2014 for a different development. There was a study in 2014 that considered a number of uses, including apartments to the south of the Walmart neighborhood market. And then as the development, as happens over time, the development changed and updates were done, including comparisons of the traffic actually being developed with what was studied in the original study, which showed a minor change in traffic, I believe, perhaps a 2% total change in traffic from the project, which I believe was at the time of the Burger King development. The development of the Burger King site coming in was shown that what was actually in place at that time, plus Burger King, was approximately a 2% change in the traffic generated by the development.
So would it be fair to say that the conclusions drawn in that earlier traffic study represent a condition that's not actually on the ground?
That would be accurate in the fact that the apartments have not been developed yet. So.
And you're aware of the condition on the approval
I am.
regarding doing a site plan or a traffic
Yep.
for this site. Thank you.
Yes.
And the owner intends to conduct that traffic study?
Yes, and I believe I can shed a little light on that I don't was like kicking the can down the road aspect of it, but the traffic study needs to be based on what is actually going into each of those potential buildings on the site. And so without having every little bit of it determined at this time of what exactly is the use, exactly how big is that building going to be, how big is the drive-through use going to be, how big, what other uses may be on the property. At the time that's brought forward with a full and complete development plan, then the traffic can be generated for those uses at that time. We end up in the same situation as led to previous, I believe, issues with the Burger King, where we're changing the traffic study over and over again as changes happen, and as opposed to having a actual what is going in, so we can actually measure the impacts of those uses and how to best mitigate the traffic from those uses. So,
Based on what we've discussed, is there anything else that you'd like to add?
I think that the PRT comments are fairly traffic. If you meet the threshold. If you meet the threshold, you will need to do a traffic study, as the typical comments in the PRT. And depending on the size of your different uses, that can usually be determined. But again, we're doing it no matter what the size is, even if it was a rather small non-traffic generating, non-higher traffic generating use. We're doing a traffic study here for this project that will, in essence, look at the concerns that the neighborhood has raised and mitigate them, propose mitigation for any concerns that this development impacts this development has on those concerns. So,
And the owner intends to work with the city traffic engineer to make appropriate mitigations.
correct. Yes.
Okay.
As the owner, they often work you on making on making mitigations. So.
Thank you. Mr. Chavez, I think it would be appropriate to pause now, and I'm not done with my presentation, but I think if there's cross-examination for Mr. Butero, that would be timely.
Absolutely. Mr. Comfort, do you have cross-examination questions only for Ms. Butero, Mr. Butero? No. This isn't a time to make any argument at all. This is your opportunity to only ask questions of Mr. Butero regarding his testimony. If you don't have questions, that's fine, okay? But I'll let you make an argument later, but not now, okay?
A clarification? Can I?
Questions to Mr. Butero only.
No.
Okay, thank you. Okay, Mr. Butero, I have a few questions, if you wouldn't mind answering them.
Certainly.
Great. So I understand that in the TIS that related to the project south of this project, Mr. Brown specific, and I know Mr. Brown, he's testified in front of me many, many times. And as I said, I know that he's an expert, and I know that he's an expert in traffic impact studies, and he does quite a few of them, and I've read quite a few of his. I'm certainly not an engineer, but I understand the general concepts of most of them. So he recognized that there are some moderate impacts, and I understand moderate impact is not a material adverse impact, even under normal language parlance. certainly not under a engineer's analysis. So he did recommend some of these mitigation measures. But in his analysis, he determined that even in a no-build situation, the traffic impacts would not significantly change between a no-build and a build circumstance. Am I reading that correctly?
There's yes, there's often, I don't know which intersection's speaking to correctly, but I would say in general terms, the first step is to analyze the existing conditions, what exists out there today, and specific to the driveway A that was brought up. There was existing traffic in the no build condition that accounted for the existing gas station at the corner site. So that was already accounted for in the background traffic of the traffic study. So that's what a traffic study does, is analyzes the background and then the additions to the background. So yes, there are oftentimes intersections that are already have issues before a development happens, and a development may or may not exacerbate those issues. And if it does, then it usually has mitigation measures to mitigate those issues. So
has the mitigation measure, the first mitigation measure that Mr. Brown recommended regarding the turn lane from Unser turning east, has that mitigation measure has it been implemented or is in the works to be implemented? I
believe, in looking at an aerial photo, Mr. Brown recommended that there be two eastbound to southbound turn lanes from Ladera south to Unser. And from an aerial photo, it appears there are two eastbound to southbound right turn lanes from Ladera to Unser Boulevard.
Okay, and they're being used right now, or I thought one was reserved.
It's hard for me to tell from this aerial photo if anything is striped, but it does not look like they are. It looks, I can see the crosswalk is rather wide across those right turn lanes that go through that intersection. So.
Now the driveway A that was referenced in the TIS, that was the one that was closest to the intersection of Unser and La Ladera on La Ladera for the marketplace development, correct? That's the first entryway.
I would point out it's actually the second entryway on Ladera. So the first entryway is a right-in, right-out entrance only into the Valero gas station. The second entryway, which the driveway A does line up with the driveway to the extra space storage across the street.
So Ms. Harvath was correct then, and I was incorrect, because yes. I was looking at the site plan on page 54, and it shows the driveway as A, and so that's what I was referring to. So that's incorrect now. That would be incorrect today.
I'm trying to find page 54. Is that in the appeal?
It's in the record of this appeal? Yes.
Okay. And
I'm not sure what page it is of the TIS, but it's towards the end of the TIS.
Sure. I think driveway, the site plans I have seen from the TIS, I have the TIS as well as the appeal. I believe A is labeled, not the driveway that comes directly into the Valero site, but comes in at the midpoint between two pad sites that are part of the Heritage Marketplace. So
I do not have that. Okay. I'm pulling it further larger. Yeah, I can see it. Okay, my apologies. I was wrong with that. Okay.
Yes.
And there were marked C. It's actually marked driveway C.
C is on Unser. So the plan in the traffic study is actually turned sideways. So Ladera Street is on the right side of the page, although it's truly north in the real world. So
I understand the dimensions and how to look at that. Okay, it looks different on mine for some reason. It's blotted out. So my copy is a bad copy.
Okay.
So driveway A is the marketplace entry.
Driveway A is the entry into Marketplace off of Ladera Drive, yes.
Got it. Okay, thank you.
And at the time, the extra space storage was developed on the north side of the street that crosses driveway A left turn lane, a eastbound to northbound left turn lane was added on Ladera. So the plans for Marketplace don't show that. I think a newer aerial photo would show that there is now a left turn lane into the shared driveway that would be between our site and the extra space storage site. So,
And that's the driveway that the appellants are most concerned with. So
correct.
Okay, great. I don't have any follow-up questions. Ms. Jacoby, any redirect?
No. Thank you.
Great. Thank you so much. Thank you, Mr. Butero.
Thank you.
You'll have to forgive us all.
Yes.
Mr. Chavez, if you'll indulge me, I have a very short argument with respect to 2019 approval.
As long as
We weren't
you-
excited about it earlier, but I would like to make it fast.
Okay.
And that is that an identical conditional use was approved in 2019. The reason we're back here is that it's expired. That decision was based on the same criteria, and it found no significant and material adverse impact. That's at page 148 of the record.
But how is that relevant when I don't even have the record to that? I mean, it's not relevant here today. And moreover, I know it wasn't appealed. And so I don't have the record because it wasn't appealed. So
Exactly.
So I don't know. I will.
The one sentence argument I would like to make.
Go ahead.
That was a finding of the city in 2019 that this particular kind of conditional use did not have an adverse impact, and that the evidence from the appellants should be focusing on what's different between 2019 and now that would indicate that now there is an adverse impact. And I don't think that there's anything in the record to support that. But that I put it in the record. I understand that you do not fully embrace that.
Well, no, it's not that I don't embrace it. I just don't find it to be relevant because I didn't look at it, and because it wasn't appealed. And certainly it may make a difference to you folks that it wasn't appealed, but it doesn't have any relevance for this hearing. But let me ask you this question about the site plan. Is there a site plan that's been approved by the DRB for this particular, what is it, 1.5 acres of land?
My client is shaking his head no. I have no personal knowledge, and so you may want, if you want more details, we should call him back.
So a site plan has not been approved by the DRB for this location.
No, I think that's when this particular uses would be further determined and the traffic impact study would be done, because traffic sits on DRB, and so that's when it would typically be done.
Okay.
Because at that point, you're getting into the nitty-gritty engineering details, and you're not thinking theoretically anymore. Okay. So there is a site plan though for development, which is not the nitty-gritty site plan, or site plan for subdivision. Sorry, there's a site plan for subdivision, I think, that was done in 2019 that is in the record. That's at page 152. And I would like to point out that at that time, we were already taking a look and envisioning that there would in fact be probably be drive-throughs, that this is an appropriate kind of area to have drive-throughs and that we should be planning appropriately for that. I'll go ahead and share my screen so that you can see. This is page 2 of the site plan for subdivision, which again is not the final site plan for development, but it is an earlier, more conceptual plan. And so here on page 2, this B3 note provides that that we're envisioning that there probably might be drive-up service windows, and it provides some specific design criteria that would start to mitigate some of the issues of having a drive-through. And so we've got those three conditions that are above and beyond what the IDO was requiring at that time to further mitigate any issues with drive-throughs. And it recognized that at that time, drive-up facilities will require a conditional use. You know, there is another process to go through, but we're envisioning that it's likely enough that that you will apply and get one for this kind of site because you're along Unser and Ladera, and this is exactly where we want automotive oriented uses, that this is likely to happen and we should go ahead and plan accordingly. And so that is in the record, which takes me to the idea of what the city council has done most recently, which is actually update the IDO with respect to where drive-throughs are allowed. And so the city council did their annual update, which
The July update is what you're referring to.
yes, so they became effective August 1st this year. And drive-throughs, this property, it's undisputed, is MXL. It's a mixed zone light use. And so those are the uses that we're looking at. And so if you look at table 4-2-1, when we started this process, drive-throughs are considered an accessory use. They're not a primary use, they're accessory. And MXL, under the prior version of the IDO, identified drive-throughs in the MXL zone as conditional accessory. As of August 1st, if you look at the new table, they are accessory permissive. And so no conditional use is required for drive-throughs anymore on MXL properties. We want to finish out this application because we've met the criteria for a conditional use, but I think that it is, it bears substantial policy weight that city council through that last update made a policy determination that MXL properties are appropriate for drive-through uses, period. There are still use specific criteria for drive-throughs. They're in no way not regulated. On this site, they're even more regulated because of the various conditions and the criteria on the site plan for subdivision. And there's lots of ways that they've been sort of improved, made better, and limited in this particular property and in the IDO in general. But city council has determined in the MXL zone, if you meet those conditions, they should be allowed as a matter of right. And
let me ask you this question, because I'm familiar with that, with the August, July.
Yes.
How do you propose that I apply retroactively a policy that doesn't apply to this application?
I think that it demonstrates the policy of city council. I don't
You just think I should take notice for this?
yes, I don't think it's regulatory upon you, but I think that
I don't know if that's lawful.
Policy of city council.
I don't know if that's lawful or not. I'm guessing it's not because it's ex post facto. It's a retroactive application of a policy, even if it's judicial notice. I don't think it's, I see that it should carry some weight, but I don't, to what extent, I don't know.
I'm not saying it's determinative, but I do think it has weight because I think that if you look at the record of how that legislation was developed, this was in no means just something that was slipped through. This was something that was carefully debated at city council, and they made this determination specific for this type of property.
Okay. I'm not going to look at that record, by the way. It's not in my record. I'm not going to muddy the waters further by including something that shouldn't.
I think that you can look at the current IDO and see that the change was made, and that's a matter that you can take judicial notice of. Otherwise, I would have submitted materials. And so the real question is, did the ZHE adequately consider the impact on traffic on this site for purposes of approving the conditional use? I think that the evidence shows the ZHE had every reason to doubt the significance of a 7-year-old traffic study that was not on the subject site, to believe that a new traffic study that would be required and fully vetted by the city's traffic engineer on the subject site, specific to the uses that are actually going to be developed, was the best way to analyze and mitigate those, and that meets the requirements of a conditional use that any material adverse impacts be mitigated. And as you noted, even the existing traffic study, which was for a much more intense use and site, because remember, our site is only I think it's less than 1.5 acres. There can only be so much traffic count that's going to come out of there. Even the traffic study to the south, which was on a much more intense site, did not particularly meet the threshold of material adverse impacts. And so the ZHE had every reason to believe that the condition to require the traffic study and to do the mitigation that was indicated by that traffic study would fully meet the criteria of a conditional use. And so I think that the ZHE considered this very carefully. I think that he crafted very specific findings that are consistent with the requirements of the IDO, and that he considered specifically the issue of traffic and addressed it adequately. And I think he was within his discretion and judgment to do so. I certainly think he's supported by substantial evidence, and that he did not abuse his discretion or act arbitrarily and capricious in acting that way. And so we would appreciate your careful consideration of this matter, and would ask that he be affirmed.
Okay. Thank you so much. Thank you, Ms. Jacoby. Mr. Comfort, this is your opportunity to rebut the arguments that were made. And please try not to be repetitive with what you've argued before, okay?
Yes, sir. I have a question of you, sir, if I may, in reference to the talking about the 2019 approval, because I requested that, clarify what occurred back in 2019. And I noticed Ms. Jacoby was allowed to go a little bit in depth on what occurred there.
I stopped her and I told her it's not relevant, just like I told you it's not relevant. So.
Okay, it was just about the approval, not so much of the detail, but the approval process, because we weren't aware of it at that time in 2019 that anything occurred, because we were in a transition state at that time. So nobody was aware of what was occurring at that location.
I understand there may have been valid reasons for never appealing it. I've been doing this a long time, Mr. Comfort, so I understand those issues. But the approval itself, in my view, is not relevant. So I'm not going to bootstrap a previous approval that expired on the requirements under the IDO for my review of it now, because the 2019 approval was based on evidence that is not in the record today. And so because there's no evidence in the record regarding that approval, it would be erroneous for me to use that as a basis for bootstrapping it into another, approval. And
no, sir. No, I understand that. As you mentioned, we approved it, and we did not because we weren't aware of it.
I don't assume that at all. Okay.
Thank you. But I did have a neat clarification, Ms. Jacoby, on the condition.
Hold on, Mr. Comfort, you cannot ask questions of Ms. Jacoby, and it's a silly rule, but she's an attorney, and you can't cross-examine attorneys. Ask your question of me, and then I will ask Ms. Jacoby if she would like to answer.
Okay, I apologize.
I don't have a problem doing that. Okay.
Thank you. I was just trying to get clarification on that conditional use number 3, where in reference to the traffic impact study. Now it says, I'm not quite clear, was a traffic impact study going to be done prior to development of that property, or after that property, part of that drive-through area was developed, and then any future development in that area, a traffic impact study was going to occur?
I can answer that question for you. It appears, and I know this for a fact, actually, more than appears, the site cannot be developed until they meet all the requirements of development. One of those requirements, when they submit their site plan for building permit, will have particular uses. So if that use is a restaurant with drive-in service, drive-up service, then it'll probably, and I say probably, but based on the previous TIS for the site below that, it'll probably show that there's going to be a threshold. That is, it's going to meet the daily threshold easily, probably by 10, nearly 10. And so they will, the city traffic engineers and the DRB will likely require a traffic impact study. And then what normally occurs regarding mitigation recommendations is those recommendations are either accepted or not accepted by the DRB. They might be implemented, they may not. The city may negotiate with the landowner for some of the mitigation measures that are planned or that are recommended, I'm sorry, because some of the recommendations might be very, very, very expensive. And so usually there's some negotiation with some of those recommendations. But to answer your question, the development cannot put concrete in until they meet the requirements, which will likely include the traffic impact study. The DRB probably won't even review it until there's a traffic impact study. I mean, that's been my experience in reviewing appeals from the DRB in 17 years now. So, Ms. Jacoby, I'll give you an opportunity to clarify any mistakes that I've made in answering Mr. Comfort's question.
I think you're accurate. I think the record also reflects that the condition specifically says that any further development approvals are conditioned on getting the traffic study. So it's not even laying concrete, it's any next development approval. I think that next one probably is a site plan for development at DRB, but I don't know that for sure.
Okay, Mr. Comfort, now, this is a time for you to make your rebuttal arguments. Please, no more questioning, okay?
Okay, so let me try to see if I get this right here. The bottom line to me in regards to this appeal was still for the traffic impact study should have been done prior. And we go back to, it was already confirmed that driveway A, which is part of that center cut, is directly across from the entrance. And that's where the primary issue is. And Ms. Jacoby was correct that no traffic impact study hasn't been done for a while. It's been adjusted for a little bit. That's why a request was made to at least get a traffic impact study done now. That's the primary thing due to the safety issues that we experience around this area. And it is very, without repeating myself, I'll try not to. It's just that intensity. So we feel that the ZHE should have had a traffic impact study done in this case.
Okay, thank you so much, folks. Okay, so Mr. Comfort, for your awareness, I will consider all this evidence and draft a recommendation to the City Council within 15 days, and I will submit it simultaneously to all parties via email through the email that we received from the city clerk regarding this Zoom hearing. Okay. Please do not communicate with me during this process. When I do send the email with my recommendation, do not attempt to respond to my email. I may ask you to affirm that you received it. Just tell me you received it. Don't ask me questions. I can't answer your questions, okay? And we'll see how it turns out. Okay, good luck, everybody. Thank you so much for your time, and we will go off the record. Ms. Jacoby, do you have any final questions for me?
I think I missed a little bit of your answer earlier, and that you may have said that a traffic study may not be required if thresholds are low enough.
Correct.
Condition in the from the ZHE says, I don't care if your thresholds are low, I'm still requiring a traffic study. So I just wanted the record to be clear on that. I don't know that that's going to turn your decision, but I didn't want an inaccuracy.
Well, it's just a recommendation. It's not a decision. Thank you for bringing that up. Let's go back to that. I wanted to see something in there real quick, and my apologies. We're opening the record back up again. Okay, yeah, Ms. Jacoby, generally agree with what your statement is. So, okay, I just have concerns with the language, but like, my concerns are probably a little too petty. So
He strung a lot of clauses together on this condition, but I think that it requires a traffic study,
no, I understand.
standing the thresholds, and it says then you will do mitigation.
It's a well-written legal condition. I you know, I mean, that's why we have so many attorneys in this world, right? Nobody can agree with. Yeah. So anyway, so thank you so much, folks. Let's go off the record, and I will send my recommendation to everybody simultaneously within 15 days. Okay.
We
Thank you
appreciate
so
it. Thank you, Mr.
Bye-bye.
Chavez.
Thank you.